I'm gonna pick up where we left, which is from Cornell Law School 11 U.S. Code 541, property of a state. We was at 8B. The debtor has no obligation to repay the money, redeem the collateral, or buy back the property at a stipulated price. And C, neither the debtor nor the trustee has exercised any right to redeem provided under the contract or state law in a timely manner as provided under state law and section 108B. 9. Any interest in cash or cash equivalents that constitute proceeds of a sale by the debtor of a money order that is made. 8. On or after the date that is 14 days prior to the date on which the petition is filed. And B. Under an agreement with a money order issuer that prohibits the commingling of such proceeds with property of the debtor, notwithstanding that contrary to the agreement, the proceeds may have been commingled with property of the debtor. Unless the money order issuer had not taken action prior to the filing of the petition to require compliance with the prohibition. Or 10. Funds placed in the account of a qualified able program as defined in section 529(8)(b) of the Internal Revenue Code of 1986, not later than 365 days before the date of the filing of the petition in a case under this title, but A, only if the designated beneficiary of such account was a child, stepchild, grandchild, or stepchild of the debtor for the taxable year for which funds were placed in such account. B, only to the extent that such funds, uh, 1, are not pledged or comprised to an entity in connection with any extension of credit, and 2, are not excess contributions as described in section 4973H of the Internal Revenue Code of 1986. And C, in the case of funds placed in all such accounts having the same designated beneficiary not earlier than 720 days, nor later than 365 days before such date. Only only so much of such funds as does not exceed $6,225. Paragraph 4 shall not be construed to exclude from the estate any consideration the debtor retains, receives, or is entitled to receive for transferring an interest in liquid or gases, hydrocarbons, pursuant to a format agreement. C1. Except as provided in paragraph 2 of this subsection, an interest of the debtor in property becomes property of the estate under subsection A1, A2, or A5 of this section, notwithstanding any provision in an agreement, transfer, instrument, or applicable non-bankruptcy law. 8. That restricts or conditions transfer of such interest by the debtor, or B, that is conditioned on an insolvency or financial condition of the debtor on the commencement of a case under this title, or on the appointment of or taking possession by a trustee in a case under this title or custodian before such commencement, and that affects or gives an option to effect a forfeiture, modification, or termination of the debtor's interest in property. 2. A restriction on the transfer of a beneficial interest of the debtor in a trust that is enforceable under applicable non-bankruptcy law is enforceable in a case under this title. D, property in which the debtor holds as of the commencement of the case only legal title and not an equitable interest, such as a mortgage secured by real property or an interest in such a mortgage sold by the debtor, but as to which the debtor retains legal title to service or supervise the servicing of such mortgage or interest, becomes property of the estate under subsection A2 or 2. I mean A1. That's, excuse me, I redact that. So that's becomes property of the estate under subsection A1 or 2 of this section, only to the extent of the debtor's legal title to such property, but not to the extent of any equitable interest in such property that the debtor does not hold. So that's under subsection A1 or 2. And then E, in determining whether any of the relationships specified in paragraph 5A or 6A or subparagraph B extends a legally adopted child of an individual and a child who is a member of an individual's household if placed with such individual by an authorized placement agency for legal adoption by such individual, or a foster child of an individual if such child has as a child's principal place of abode the home of the debtor and is a member of the debtor's household, shall be treated as a child of such individual by blood. Excuse me. F, notwithstanding any other provision of this title, property that is held by a debtor that is a corporation described in section 501c3 of the Internal Revenue Code of 1986 and exempt from tax under section 501a of such code may be transferred to an entity that is entity that is not such a corporation, but only under the same conditions as would apply if the debtor had not filed a case under this title. And I'm not going to read all the little public laws and stuff and the dates, but that reading, this is part 2 from Cornell Law School, Title 11, United States Code, Section 541, property of the estate. Property of the estate. Thank you. Peace.